Hello and welcome to this episode of the Maryland Risk Management Education Podcast. My name is Paul Geringer and I'm the Extension Legal Specialist here in the Department of Ag and Resource Economics. And today we're putting this episode out on a Monday and not a Wednesday, and it's slightly more of a timely topic than some of the stuff we put out. But today on the podcast, we're going to talk about the recent Ninth Circuit dicamba opinion that vacated the registrations for 3 of the products. And today on the podcast, we have on Brigit Rollins, who's with the National Ag Law Center and who has focused in on a lot of environmental issues, including this dicamba issue and the multi-state litigation that's ongoing on sort of the product's liability into the dicamba lawsuit. So today we're mainly going to focus in on that Ninth Circuit opinion and talk a little bit about it. So I will turn it over to this pre-recorded interview with myself and Brigit and hope you learn something from it. Brigit, why don't you tell us a little bit about who you are and what your role is and what you do, and sort of just give us a little bit of background before we get into this dicamba issue.
Hi, everyone. My name is Brigit Rollins, and I am a staff attorney with the National Agricultural Law Center. We are based out of Fayetteville, Arkansas, and we provide information and education on issues around agriculture and the law and how those areas kind of bisect. I focus specifically on environmental issues within ag law. So I've done a lot of work on the Clean Water Act, the definition of waters of the United States, and I've done a lot of work on pesticides and dicamba in particular. And I graduated from the Lewis and Clark Law School in Portland, Oregon. So I'm a West Coast native and moved out to Arkansas less than a year ago to start working with the lovely people at the center.
Very cool. And then got hit with the pandemic and have probably got to enjoy staying at home for a while.
It's been nothing but a good time here.
So your work on dicamba is the main reason I had asked you to come on, because you've kept up with a lot of either the class action lawsuit that's progressing through Federal District Court in Missouri. I can't remember which, the Eastern District of Missouri. If I remember
the Eastern District of Missouri, that's right.
But the main reason is we have this Ninth Circuit decision on the use of 3 products currently. It doesn't impact the 4th product, if I remember correctly.
That's right.
And I'll just start us off with, why don't you tell us a little bit about what National Family Farm Coalition, what the lawsuit is about, in particular versus EPA, and what some of the facts are, and what sort of the gist of the case has been, and where we're currently at with that decision.
So this case is very interesting, and it does have a very interesting background. It was brought by the National Family Farm Coalition and 3 other plaintiffs, 3 other groups, the Center for Food Safety, the Center for Biological Diversity, and Pesticide Action Network North America. And they originally brought this case way back in 2016. Way back in 2016, when Monsanto had originally registered Extendimax, their dicamba-based pesticide, for over-the-top use on crops. And that was a first that a dicamba-based herbicide had been registered for that kind of over-the-top use. Prior to that, dicamba pesticides were primarily registered and used as pre-emergence. So they would be applied in the winter or early spring just to kind of kill weeds before seeds got put in the ground. And the reason why this pesticide Extendimax got registered for over-the-top use is that Monsanto had released in 2015 a line of dicamba-resistant soybean and cotton seeds. So they had released those in 2015, and then the next year, EPA had registered for use dicamba pesticides. And the idea for Monsanto's thinking was that these things would go together. Farmers could buy these dicamba-resistant seeds, and then they could buy Extendimax to use on those seeds. And kind of another little background piece of this is that dicamba has been used kind kind of to target specifically very difficult to get rid of weeds like Palmer amaranth, commonly known as pigweed, which have grown resistant to glyphosate or Roundup, as that's more commonly known. So there's just kind of all these little background pieces that kind of lead to this case. So EPA registered XtendiMax in 2016, and the National Family Farm Coalition, along with those 3 other groups, they filed a lawsuit against EPA alleging that the registration violated both the Federal Insecticide, Fungicide, and Rodenticide Act, which is usually shortened to FIFRA, and that those registrations violated the Endangered Species Act, the ESA. So that case progressed through the court system, and by the time it made it before the Ninth Circuit, they kind of had this problem where the 2016 registration had expired. So it was a 2-year registration that was set to expire in late 2018, and it had. By the time it reached the court, that 2016 registration had expired, and EPA had renewed the registration for another 2 years. So the court said that that case that had been filed by National Family Farm Coalition at that point was moot because the 2016 registration that they were challenging was no longer in effect. But it did allow them to refile for the 2018 registration, which leads us to the case today. So the case today that we're going to be talking about challenges not just the registrations of XtendiMax, but also Fexapan and Ingenia, which I believe I'm pronouncing correctly.
I believe you are too. That's how I pronounce them. So I think you're right on that.
You know, it's funny, some of these pesticide names, they have these, they have these spellings and you're kind of hoping for the best. So Fexapan and Ingenia were also registered for use by EPA. Those are also over-the-top dicamba-based herbicides. And Fexapan is owned by DuPont, which is now Corvetta, and Ingenia is owned by BASF. And kind of another little tidbit here, Monsanto, which originally developed XtendiMax, has been bought by Bayer. So just all these little moving pieces. So this case, National Family Farm Coalition refiles against the 2018 registration, but they're making those same arguments that EPA violated FIFRA and the ESA. And in particular, they're kind of claiming, so their FIFRA arguments are that EPA did not support its findings with enough evidence. So they say that EPA did not have enough evidence to make the conclusion that that these 2018 registrations, when they register these pesticides, EPA has to show that it has evidence that registering these pesticides will not significantly increase the risk of any unreasonable adverse effect on the environment. And National Family Farm Coalition was challenging that and saying, you did not have enough evidence, you didn't do the work that you needed to do to show that. So these registrations are invalid. They also made some ESA arguments, which I don't want to get into as much because the court did not reach any of those arguments in its decision. But essentially, National Family Farm Coalition said that EPA did not really do the ESA consultation that it was supposed to do. But again, that's going to be sort of tangential because the Ninth Circuit did not reach that. So as we all know, kind of are aware, the Ninth Circuit issued its opinion on this case on June 3rd. And in that opinion, the Ninth Circuit has sided with the plaintiffs, with the National Family Farm Coalition, and they have agreed that EPA did not adequately show that these registrations would not create an unreasonable adverse effect to the environment. And that's kind of where we are. They vacated those registrations based on that. And now we're kind of trying to figure out what's going to be that next step.
That kind of leads into my next question, but before we go into the Ninth Circuit opinion, I just want to have somebody also clarify this so it's not just me doing this. What relationship does this have to the multi-district litigation that is ongoing in that Eastern District of Missouri with some of the damages related to these products?
That is an interesting question. To my knowledge, these two cases aren't really related at all. This Ninth Circuit case, you have these organizations, you have these organizational plaintiffs who are challenging the registration, these underlying registrations. Whereas this multi-district litigation that's in the Eastern District of Missouri, you have farmers who are alleging that they have experienced dicamba damage, and they're bringing primarily state law tort claims against the manufacturer, against Monsanto. So it is possible, I suppose, that the plaintiff's attorneys might reference this case in their arguments when they get to a jury, but otherwise these two cases don't really have that much in common, except for that they're both related to dicamba use.
Yeah. I just kind of wanted to have that little bit on clarified for folks, because I get that question a lot.
Absolutely. And it sounds on the outside, right? They're both talking about and related to dicamba use, but when you get into the legal arguments that are being made and the complaints that are raised by the plaintiffs, they're very distinct.
Yeah. They are very distinct, and there's a lot of different things going on in each one that makes it hard to make that relationship stick more than, like you said, there's just dicamba products involved.
Absolutely.
Yeah. So going back to the Ninth Circuit opinion, what does that mean right now? What do we know today when we're recording this on Thursday? Is it June 11th?
Yes.
Yeah, June 11th.
It's June 11th.
Me either. Can't believe that either. But what does that mean on June 11th that we currently know about what this opinion means? Because we've kind of been in a state of flux since it came out last week. And EPA, we'll talk about later, has helped clarify some stuff. But what do we know today?
Right now, the Ninth Circuit, kind of its ultimate impact is that those registrations for Extendimax, Fexapan, and Ingenia have been vacated, which means that those no longer have a federal registration. And just from the text of FIFRA, if a pesticide does not have a federal registration, it cannot be distributed or sold. And we'll get to a little later, EPA has released some guidance on that. That's going to clarify things a bit. But right now we are in this position where these three pesticides, they've had their registration completely vacated. So they are no longer registered with EPA. And as far as getting into the why of it, why the court ruled this way, we're going to have some interesting precedent where the court said not only did EPA so in the opinion, the Ninth Circuit says that EPA, when it considered, there were three factors that it pointed to that said, EPA, when you made your registration decision, you highlighted these three factors as potential environmental impacts, but you ultimately decided that these would not lead to adverse impacts on the environment. We think that you did not look at these factors closely enough and that you didn't take into account everything that was going on. And we also think that there are three things that would lead to adverse impacts on the environment that you did not look at all. So it's highlighting areas where EPA didn't do enough consideration and areas where EPA didn't do any consideration at all. And going forward, that might mean that any registration for a pesticide that EPA does where it doesn't consider these three things, it could mean that plaintiffs could bring cases in the Ninth Circuit, and that the Ninth Circuit could decide that EPA has not done enough if it hasn't considered those three factors, which are, for anyone who is interested, kind of the three things that that the Ninth Circuit thinks EPA failed to acknowledge in its registration of these pesticides were potential non-compliance with label requirements, economic costs, and social costs. And I think we could see that going forward, that EPA might have to, when it's registering a pesticide, really give those things more consideration, or at least perhaps consideration that it has not given to those factors in the past.
No, I could see that too. And yeah, we don't know what level yet even the consideration is, because
Exactly. We don't know what level yet. So I think as far as where we are on June 11th of 2020, these 3 pesticides have had their registrations vacated, and the Ninth Circuit's opinion could mean that how EPA registers pesticides in the future will be changed, but we do not know yet to what extent.
and that kind of leads into question 5, because the label and the registration were expiring for these products later this year.
Yes.
And EPA was going to have to go through a renewal process. What does this decision do to that renewal process for these 3 products? Are we going to have, do we know if we have to take these 3 factors into consideration? What do we know right now?
That is a really good question. And I think my answer might be slightly disappointing in that I don't know what impacts this case could have on the renewal of the labels. Kind of an interesting wrinkle to this case is that the registrations that were challenged, they had been registered under a portion of FIFRA which allows for kind of a conditional new use registration. So it wasn't that typical FIFRA main kind of registration. This was a particular kind of registration that allowed for that 2-year period to occur. So it's going to be interesting to see what this opinion does have on the registration going forward, because it will be registered under a different section of FIFRA. So kind of that annoying lawyer answer of it depends.
Yeah, I agree. People hate that, but we don't know yet. We know what the factors may be, but we don't really know how any of this is going to play out.
Exactly. We don't know yet.
So moving forward to what EPA has done based off this court ruling, they issued an order on June 8th, I believe. So yes. What does that order do exactly, and what should growers and other people be aware of what's happening now that we have this ruling and EPA has made a decision on how they're going to handle these 3 products?
So EPA has issued what they're calling a cancellation order for these products. And so again, that kind of ties into FIFRA. Under FIFRA, EPA has the power to cancel pesticides. And when pesticides are canceled, the regulations of FIFRA lay out kind of what happens next. And that is important, that this is a cancellation and that EPA considers this a cancellation, because that kind of determines how we got to this cancellation order. So in the cancellation order, EPA lays out sort of that its view and the path it has decided to take when courts cancel registrations, when courts vacate registrations, is to treat them as though EPA has canceled it. And when EPA cancels a registration, that generally means that these pesticides are no longer registered, so distribution and sale has to end. However, EPA does have some wiggle room to decide what to do with existing stock of pesticides. So existing stock kind of defined as those pesticides which are sort of already in circulation in the market when these registrations are vacated. And that's great, because that does mean then that EPA, has some authority to allow for use and even limited distribution of existing stock. And it's important to understand distribution is a very, when we say that, it has a very broad definition, because it includes things like you might think when you think, okay, to distribute for sale. And it does mean that, but it can also mean shipment, in the sense of, like shipping a pesticide that, in particular, shipping pesticides, say, back to the manufacturer for proper disposal can be viewed as distribution and is included in that definition. So the order gives us some clarity and some kind of guidance as to what we can do with existing stock. And it has outlined 4 particular things. So first, the registrant of these pesticides, so those companies that registered them with EPA, they are no longer allowed to distribute or sell any of their pesticide, any of their existing stock after June 3rd. So after the Ninth Circuit's opinion came out, these companies that have made these pesticides and registered them with EPA, this order says they are no longer allowed to distribute or sell them. The second thing the order says is that distribution or sale of existing stocks that are already in possession of people who aren't the registrant, that will, so like third party sellers, that sort of person, they are now only allowed to distribute or sell those existing stocks if it's for the purpose of returning them to the manufacturer for proper disposal. So, you know, if a third party seller has these, right now this order is saying the only thing you can do with them basically is ship them back to their manufacturer. The order has kind of this interesting note here about commercial applicators. So if you're a commercial applicator, for the purpose of, so if you're a commercial applicator, EPA is saying that you may actually engage in distribution or sale of existing stocks of these products, but only if you're doing so for the purpose of getting them used before July 31st of 2020. So that's kind of an interesting little thing that commercial applicators can take advantage of. And then finally, EPA has addressed use of existing stocks of any of these pesticides. And they're saying anyone who has these pesticides can use them consistently with their label requirements up until July 31st of 2020. So those are sort of that's what EPA has laid out in its order about what is and is not allowed. And that's what we know as of today, June 11th.
I think we have to keep adding that date in there because at some point all of this will change and it will be out of date.
Yes.
So looking at that guidance, you've kind of talked about what you think about it already, but how does it compare to other pesticides that have had registrations vacated in similar situations or similar cancellation orders?
So I think this cancellation order is fairly similar to what we saw in 2015 when the Ninth Circuit vacated sulfoxaflor, which again, I cross my fingers and hope I'm pronouncing correctly.
Sounds pretty correct.
Yeah. Again, we had this instance where the Ninth Circuit, a federal circuit court of appeals, vacated a registration order, and EPA issued a cancellation order similar to this one where they said, we're going to treat this as a cancellation. And that cancellation order, it did not as thoroughly go into some of the factors that EPA considers when it cancels a pesticide. I think we see that a little bit more in this order. But what is kind of similar is that EPA addresses use. Again, in that 2015 sulfoxaflor order, it did say, you know, we will allow people who have this product already to use it according to the label until this particular date. The sulfoxaflor order, it's tricky. It's a tricky one to pronounce.
I'm glad you're pronouncing it and not me.
I'd like to thank high school theater, where we had to say tongue twisters over and over again for my ability to pronounce a word that has that many L's so closely together. But you know, in that order, we also saw EPA restricting distribution and sale in a very similar manner to here. I think really the thing that kind of is the biggest difference I see between those two orders is that the one for these dicamba pesticides allows commercial applicators to engage in a limited amount of distribution and sale, whereas the sulfoxaflor order did not address commercial applicators at all. And I don't know enough about commercial applicators to speak to why that is, but I think it's a very interesting little wrinkle there.
That is an interesting wrinkle. And I'm curious to see how EPA's order and guidance will hold up over the next couple of weeks.
I think we all are.
Yeah. Yeah. So any parting thoughts on dicamba?
It's a very interesting issue. I think you mentioned earlier, it's important that we keep mentioning the date that this is being recorded, because this could very well change and things could very well be different even by the date this podcast is released. So anyone who's interested in this, definitely keep your finger to the pulse of what's going on, because we could see changes, clarification. We just don't know yet.
And I better say, and in the show notes, I will put a link. I know you've done a bunch of blog posts for the National Ag Law Center's blog related to dicamba, and I'm sure if something changes, you'll be putting out new information, and so folks can go there and find the latest.
Yes. The national, on our website, which I guess I should say, I'm sure you'll include the link to the website, but
I will.
Website, nationalaglawcenter.org, we have a blog where we publish weekly articles and daily updates on regulations and cases and legislation. And on that blog, I have a series called The Deal with Dicamba. And the first 8 parts of that series look at not just this Ninth Circuit case, but also the multi-district litigation that we mentioned earlier, the Bader Farms litigation that people might be aware of, and some state litigation here in Arkansas concerning dicamba. So if anyone wants to do a deeper dive into some of the arguments that are being made and why they're being made, that series is there, and it will be updated accordingly as more stuff happens.
Cool. That's very good. I've found it very helpful during all of this, and especially with the multi-state litigation, it's been very helpful to stay up to date. And for myself, not have to read the multiple page opinions that can be published.
Oh my goodness. Yes. I think I feel very comfortable saying I have definitely read over 1,000 pages in court documents just related to the multi-district litigation.
Oh yeah, the multi-district litigation is insane. Oh, well, I want to thank you again for coming on the podcast today, and I will put contact info for you as well. I'll put your email in there so folks have questions, they can directly email you.
Wonderful. Thank you so much for having me. I'm very excited to get to talk more about this. It's a very interesting topic that there's always something there's always something going on.
Thank you again for listening to this episode. I want to make sure you're aware, I did put Brigit's contact info down at the bottom and links in the show notes as well to the blog post she's worked on at the National Ag Law Center, a link to the National Ag Law Center, and I've got the EPA order also linked in there as well, so you can be aware of that and the guidance that EPA has issued for those 3 dicamba products. Thank you again for listening. If you have any thoughts, questions, topics for future episodes, please use my contact info down below. You can email me, tweet me, or find me on Instagram. Thank you again for listening, and enjoy the rest of your day.